Hello, I'm Caitlin Jenkins. I'm the family law blogger from Mills and Reeve, and today is a big day in family law. It's the day that the law has changed to become no-fault divorce, and I'm delighted to be joined by my colleague Nigel Shepherd, Mr. No-Fault Divorce himself, to talk about the practical changes today and also some of the background to it, because Nigel has been involved in this movement towards divorce reform for a very long time. So welcome back to the vlog, Nigel, first of all.
Thank you. Lovely to be here, Caitlin, as always.
Absolutely, on a very important day. So 6th of April 2022. Let's look first of all at the practicality. So the change is around divorce law in England and Wales is what we're talking about. So let's just run through the key changes to remind people. So the ground for divorce, if I understand correctly, has stayed the same. That hasn't changed. Is that right?
That's right. It's still the irretrievable breakdown of the couple's marriage. What's changed is how you evidence that. So instead of the grounds that we had before today, anybody starting proceedings from today onwards for a divorce, instead of having adultery and behavior or separation grounds, there'll be a simple single notification period. So you make a statement, you say the marriage is broken down. There is then a 20-week wait until what will now be called the conditional order of divorce, another 6 weeks after that for the final order, so a total 26 weeks, and that will be the process from today onwards.
So that's the big change. It's not the ground for divorce, which, as you say, remains the same. It's the fact that you no longer have to rely on what used to be the 5 facts. So in particular, the big bit is you can't rely on adultery or unreasonable behaviour, hence why this is being badged as a move to no-fault divorce. We're getting rid of those fault-based factors. But there's some other quite big changes, aren't there, I think, because thus far you've been able to make a sole application, but am I right in thinking that couples from today could make a joint application for divorce?
That's absolutely right. It's a very major change. It's a very important change as well, because for a lot of couples, they both recognise that their marriage is broken down. Not only don't they want to be forced into playing the blame game by alleging adultery or behaviour in order to get on with the proceedings, but they would like a process where their mutual decision can be recognised within the process itself. So they're making a joint statement that they both believe that their marriage is broken down. It is important emotionally for them and helps them move forward. So that's a major change, and one that I think is very welcome.
I agree, and having talked to a lot of clients in the run-up to this divorce law change, they're really pleased that joint application is a possibility now. And in fact, clients over the years have been quite shocked that they can't make a joint application until the change in law today. You know, if people have got to the conclusion mutually that their marriage is over, they then have felt until the change today rather perturbed that they can't do something jointly, that one of them has to bring something against the other. So I do think the joint application is actually another significant change, as well as the blame bit that's changed. Yeah, what about costs? Because under the old law, which was in place till last night, you could seek costs if you were for the divorce process itself, if you were bringing an adultery or an unreasonable behaviour petition. But that's changed as well, I think. Is that right?
The law itself, funnily enough, hasn't changed. The rules haven't changed, but what we have had is guidance from the president of the family division that says that costs in what they call an hour standard case, in other words, an undisputed case, and we'll come to the difference between disputed and defended in a moment, I think, but in an undisputed case, the expectation is there will be no claim for costs. And the big practical aspect of that is that the actual divorce application will not have a box to tick to claim the costs. So if in an exceptional situation you feel that you want to claim costs in a standard undisputed case, you'll have to make a separate application. But the reality is this is a no-fault divorce process. And the guidance recognises the fact that if it's a no-fault process, then you shouldn't have one person paying the other person's costs just because one happens to be the applicant and the other one the respondent. So that's an important change.
Absolutely, and it's still a significant change. It would be somewhat anachronistic, particularly if you had people making a joint application.
Yeah, I mean, actually, I think if you're making a joint application, you'd expect as part of that process for you to agree on what you're going to do about paying the costs. I mean, we're talking here about the petition fee, which will remain unchanged at £593, I think. And you know, for some people, not being able to claim that back in certain situations might be an issue. The exemption for fees for those who are the least well off will still apply. But I think the important thing conceptually is a no-fault process. You shouldn't be having costs as part of it, as part of a standard process, and that's going to be the reality position in practice.
And we're talking about the cost of the divorce process itself, of course, just pausing separately. We're not talking about the costs of any discussions around arrangements for children or finances. We're talking about the costs of divorce. Okay. So you mentioned defending divorces or defences or all of those sorts of things. What's the situation under the new law now about seeking to defend a divorce?
Well, previously, I mean, for example, if you claimed adultery or behaviour, the other spouse could say, no, that's not true, and defend it. The practical position was that those cases were very rare indeed. And now you won't be able to do it. You will not be able to defend a divorce application simply because you don't think the marriage has broken down. So if it's a sole application from your other half, you can't say, I disagree. The evidence will be the statement from the person who's making the application to say, I believe the marriage has broken down. And that's a statement that will still be a statement of truth. You'll have to, say that's the case. And you'll have to say it's still the case when you apply for the final order, when you apply for the conditional order and the final order. So there'll be a number of staging posts, if you like, where that confirmation is given. But the reality is that if one person thinks it's over, the law is now going to treat it as over.
Absolutely. And there's a couple of things that haven't changed. So one thing that hasn't changed is jurisdiction. So the sort of ground for being able to bring a divorce in England and Wales, the basis on which you do that hasn't changed. We're talking about the actual process once you've got that jurisdictional hook, aren't we?
That's right, yes. And you can still challenge, if there's an argument about jurisdiction, that's one of the situations in which you can challenge it. It's not called a defence. It's going to be called a disputed case in those situations. So jurisdiction, whether the marriage itself was a valid marriage is going to be another ground, or things like fraud and things like that. So those will be the reasons for challenging the divorce, but it won't be called a defence as such.
Yes, it isn't a defence to say, I don't think my marriage is over, that it's a different circumstance. Yeah, absolutely. And then the other thing that's changed mechanically, but actually changed in terms of the access for people filing for bringing a divorce petition, we'll talk about terminology in a second, is around people can do it online through the online portal themselves on the Gov website or through solicitors. But that those mechanics have been changed behind the scenes, but there isn't a sort of new mechanism for actually bringing the process to the fore, is there?
No, I mean, there are some other changes around service. So email is going to be the default now, but the online process, the court will normally do it all for you. I mean, you could still ask for the papers back to do it yourself, but that'll, again, I think that'll be quite rare. And in international cases, the position will be different. So those cases that we're dealing with as a firm internationally, there's a different kind of service protocol. But email service, bizarrely, even though you email it to the usual non-business address, you're going to have to follow it up by post as well. So that's a little strange. But most of them are going to be online, and that process, hopefully, when everybody gets started with it today and onwards, will be robust enough to cope with the influx that we expect to see initially before things settle down again, because people have been waiting for this. Yeah,
absolutely. They've been waiting for practical reasons, they've been waiting for emotional reasons, and we'll come to some of those in a minute. One final question just on, before we look at the sort of broader picture on the actual changes that have happened today. Quickfire terminology round, Nigel. You've alluded to this already. So divorce petition becomes?
Divorce application.
Decree nisi has become?
Conditional order.
And decree absolute has become?
Final order.
There you go, marvellous. Great, so those I think are the headlines of the actual changes that have come in today. And I think just to mention before we move on to talk about the broader picture, what hasn't changed is the arrangements, the law around the arrangements for children, and the law around the arrangements for finances. Actually, one thing we should just check in, so what's happened to the law around dissolution of civil partnership? So that's not marriage, but dissolution of civil partnership. Has that changed as well today?
Only in the same way, in terms of the process being one of notification and statements. Everything else is changed only to allow that change from the previous facts that had to be proved. to this new notification process. So it's mirrored completely in that respect.
Brilliant, super. Thank you, Nigel. So those are the changes today. We family lawyers are very excited about it because it's been a very long time coming, and we'd be remiss of us not to take the advantage of talking to you about this, Nigel, given that I know you've been involved in this for a very long time, this divorce reform, which is many years coming. So what's the background? You know, where did this change in the law come from? What's the background to the groundswell of opinion to get to this stage today?
Yes, I'm sorry, Caitlin, you froze there for a moment.
Oh, sorry. I was asking what the groundswell, what's the background to the groundswell of opinion that has led to the change today, just the sort of broader picture, because you've been involved in this divorce reform lobbying for a very long time. How did we get here today?
Yeah, I mean, there's a long history of it. I mean, the first sort of major changes around this were proposed back in 1966, would you believe, when England last won the World Cup. There were some changes that came in 1969, which led to a 1973 Act, which is what we've been working with for the last half a century. There was then in the 1990s further proposals for reform, which in fact led to an Act of Parliament called the Family Law Act 1996 that would have introduced a form of no-fault divorce. But it was incredibly complex. It was wrapped up with compulsory information meetings, varying periods for what they called reflection and consideration, finances having to be settled in most cases before you got the divorce. It was overly complex, and it never actually got implemented and ended up being repealed in 2014. But the campaign went on. Resolution that I've been heavily involved with since the early 1990s, in fact, continued the campaign. But there were two, I think, major catalysts for reform other than the campaigning itself. The first of those was a piece of very detailed research done by Professor Liz Trinder and her team from Exeter University called Finding Fault, which looked at the current system, pulled it to pieces, interviewed practitioners, interviewed families, couples, people going through the process, which demonstrated absolutely clearly that the current system was both sort of legally and intellectually dishonest. It was a blame game that, most importantly, was actively getting in the way of people being able to sort things out constructively, which of course is our aim when we're helping people to do that. That was a really important piece of research, which was very influential. And the other thing at the same time, in a kind of perfect storm, was the case of Teenie and Hugh Owens. Mrs. Owens petitioned for divorce under the old terminology, on behaviour grounds. Mr. Owens defended it. It was one of those rare cases where things weren't sorted out before it got to court. It went to a hearing, evidence was given, and the judge who first heard it decided that under the current law, applying his view of that and of the evidence, Mrs. Owens wasn't entitled to her divorce. She appealed it to the Court of Appeal. They didn't feel able to interfere with the original decision because on the appeal, you can't just substitute your own view for the original judge. You have to say that something went wrong. And the Supreme Court felt the same way about it. But what both courts did was saying, we can't as a court change the law, but the government really should grasp this nettle and do it. And so the combination of the research and the Owens case and the sort of outcry really that came particularly about Mrs. Owens being trapped in this obviously dead marriage and having to wait until she'd been separated 5 years, that prompted the government to act. And so they did a consultation. The responses to that were pretty overwhelmingly in favour of reform. And it finally got through Parliament after a couple of hiccups with prorogation and general election, finally got through in June 2020. And since then, it's just been a matter of getting the forms, the rules, the online system to make sure everything's working for today, which hopefully, fingers crossed, it will.
It's incredible, isn't it, when you think how long it's been in the making, this, despite the fact that actually I think most those involved in the family justice system, whether that's lawyers or others supporting families, and indeed the families themselves, have sort of felt for some time, both on the basis of Professor Trinder's report and just instinctively from practice, that this is something that's getting in the way of actually helping families to separate in a way that minimises conflict, which is obviously important for them, but it's really, really important for the children. And that seems to be one of the sort of key themes that's continued through these campaigns that so many people have been supporting.
Yes, absolutely. And, you know, we've known as practitioners for years and years and years that in trying to help people, for example, mediate or using the collaborative law process, or just trying to help them negotiate the arrangements for their children, most importantly, the arrangements for their money, we've been doing it with one hand tied behind our backs. Because this process has set people off on the wrong track. Even people who come and say, we want to do this right way, when you have a conversation about behavior or adultery, it just gets in the way. It can really upset people and just throw them off track. So that's been consigned to history, and about time too, long overdue.
Long overdue. I agree with you. It can actually take a couple back. So with the various different hats that many of us wear at Mills & Reeve, mediation hats, collaborative law hats, litigator hats, solicitor, negotiator hats, or arbitrator, you can often end up in a conversation with clients who've got through some of the emotional turmoil around the separation and have sort of found a level playing field between the two of them, and are now wanting to take the step to divorce and having to say to them, as one had to do until yesterday when the law changed today, I'm sorry, but to actually achieve a divorce, one, you can't do it jointly, and two, one of you has to, unless you're prepared to wait certain periods of time, as the old law was, one of you has to allege something blameworthy against the other. It really ran the risk of taking couples backwards in their emotional situation, and also in their ability to communicate, which just felt very difficult. So it's a really big day for family lawyers, and hopefully for our clients and their wider families, I think. Slightly controversial question, perhaps, Nigel. Do you think there's any downside to the change in the law, or what were the, perhaps a better question, what were the nature of any objections to the change in the law over time? Was it about fault should be part of it? Was it more about some sort of wish not to make divorce easy? What were the sort of key objections to which have clearly been overcome, but what were the sort of key objections to the change?
Yeah, I mean, but we saw this particularly during the debate that led to the Family Law Act in 1996. It felt a different climate, but it was very much about, oh, this is going to undermine marriage, it's going to make divorce easy, people are going to sort of wake up one morning and just decide to divorce without thinking about it. What Liz Trinter's research showed was what we know, that the divorce process itself tends to be quite some way down the road. When people's marriages get into difficulty, people just don't wake up one morning on a whim and just say, right, I'm going to get a divorce and press a button. You know, they've normally thought very carefully about it, they've agonized over it. It's a really difficult decision. So I think that, you know, that argument was proven to be false. There are some people who think that, for example, if you're sadly the victim of domestic abuse, and we know that that is sadly very prevalent, there's a thought that maybe it can help you to say, this is the reason, you know, it's not my fault. But equally, there's some quite powerful research that suggests that if you are in an abusive relationship, the previous law, whereby, you know, you had to cite incidences of behavior, could actually make you more vulnerable, could increase the temperature and put you more at risk. Which I think is an important point to make. You know, what we would say is this process is about taking blame out of the divorce process itself. I mean, I think we're realistic enough to know that it doesn't get rid of conflict. It'll just help minimize it. It'll help people, first of all, who want to do things the right way, not get thrown off track. But we'll still have to manage that. So one of the concerns, I think, is where does the anger go? Where does the emotion go? Well, the answer is it doesn't go into the process because it doesn't help. And there's no investigation of it. There was no investigation of it under the process prior to today. The courts never looked at it unless it was defended, and that was rare. And that was actually very hard. So if you were on the receiving end of a divorce behavior petition and you really, really didn't agree with it, there was no real forum for you to sort of vent that disagreement. So it was even more frustrating, even more damaging. But we'll still have to manage that, and, you know, counseling, therapy, helping people through it, helping people find an outlet for their emotions so they can move on will remain a vital part of our job, but the process won't be getting in the way of that.
Absolutely right. And as you rightly say, this won't get rid of the emotional angle around separation, divorce, and sorting out all of those arrangements. And as a wise colleague of ours, Roger Bamber, always says there's a legal track and there's an emotional track, and the two things can cross over and make one of each of those more difficult. So there's going to have to be a way for us as advisors with the multidisciplinary colleagues, therapists, counsellors, other support to our clients to make sure that, as always, that the emotions are managed and supported, and our clients have that support as they go through this process, irrespective of what the actual legal process is.
Right.
Nigel, that is so helpful. I suppose one perhaps more personal question: how are you feeling now this is in place? I mean, it's something you've been campaigning for a very long time. How do you feel now it's actually happened? I know we had the law being passed some time ago now, and then it's just been the mechanics, but to actually have it in place today, how do you feel about that?
Yeah, I mean, it's a little surreal, really, because we have been campaigning it for so long. And I think I first got onto the National Committee of Resolution in 1991. So, and I became national chair at the time that the 1996 Act was going through, and then it didn't happen. So I became chair again in 2016 because I saw it, and Resolution saw it very much as unfinished business. And then, you know, we had the prorogation, we had the general election. You were nervous, bearing in mind what had happened before, that something would go wrong. And then the implementation date got put back from October 2021 to today, and to make sure all the systems were in place. And so now that it's happened, relief. Yeah, personal pride for my part of it, but it's very much a team effort. You know, I've been privileged to have the opportunity, if you like, to sort of lead it at various times, but phenomenal amount of work by a lot of people and a lot of things coming together to make this work. But it's a change that, yeah, we can all be rightly proud of. Most importantly, it means that we can help our clients in a better way. And that's been the motivating factor for me all the way through the last 30 years or so. So yeah, kind of my work is done, kind of, but there's still lots more to be done. And there's other changes to the law that on another occasion we can talk about that that we'll need to try and push through. But this is great news today, at least.
Absolutely, and I have to say, great credit to you, Mr. No Fault Divorce, and all the other organisations, whether that's Resolution, other individuals, organisations, and it's been such a sort of team effort, hasn't it? From individuals to those in government, to the civil servants, to the judiciary, to all sorts of range of people to actually pull together and make this change happen today for families. So that's great. Thanks to you and to all of them as well. Nigel, thank you very much for joining the vlog. Again, we've done our updates across the time, and each time we've said fingers crossed and hopefully it'll happen. Yeah. So it's fantastic that finally the law has changed and has come in today, and no doubt we can review it in a few months' time and see how it's getting on. But for now, thank you very much. And as always with the blog, we can only give general information and discuss things in general terms. So if you're a viewer and you have any specific questions about your situation, please do contact Nigel or me or one of our colleagues in the Mills and Reeve Family and Children team. And the details, all the contact details on our websites are underneath this blog. But for now, Nigel, thank you very much.
Thank you.